Okay, well, good morning or afternoon. Thanks for joining us today. You've tuned in for the webinar, What the Heck is an Industrial Design? I'm your host, Jennifer Januska. I'm the Director of Intellectual Property for Protein Industries Canada. I want to make a particular welcome to folks who have joined from across our ecosystem, and special thanks to our sister global innovation clusters for helping to promote this webinar today. We're all seeking to get you the best advice for strategic IP decisions and happy to bring you resources like this one. Protein Industries Canada, as I mentioned, is one of the global innovation clusters, and we have a particular focus on innovation in plant-based protein for food, feed, and ingredient applications. You can find out more about us from our website, proteinsupercluster.ca. Since we are headquartered in Regina, Saskatchewan, I want to acknowledge first that we are on Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, and Lakota, and the homeland of the Métis Nation. We respect and affirm the inherent and treaty rights of all Indigenous peoples across this land. We have and will continue to honor the commitments to self-determination and sovereignty we've made to Indigenous nations and peoples. Now, before we get started, let me just set the scene about industrial designs. If you came here today not having any experience with industrial designs or any knowledge of how to use them, you are not alone. In the last year that the Canadian Intellectual Property Office has data reported, there were over 37,000 patent applications filed in Canada. By contrast, there were only 8,000 industrial design applications filed. It's a very small sort of niche of IP practice. But I want to make sure that you're aware of what's possible here, because most Canadian companies are not. Most industrial design applications, even that small number that we have here, are filed mostly by US and foreign companies in Canada. But that said, everyone on this call today can recognize that the shape and appearance of products can be a major driver of purchasing decisions. And there's no doubt that it's a major investment to get the look of a product just right, to make sure that it differentiates in the market. There is room for Canadian companies to explore how to protect design and find out how to get the best scope and value. We have got a great speaker lined up for you today. My friend, Joe Conneely, is the founder of Conneely PC. He's a lawyer and patent agent and trademark agent based in Toronto. He's a professional engineer by background, and he has over 20 years of experience advising clients across all sectors, really, on ways to protect their inventions, brands, and designs. Joe has worked with Canadian SMEs, as well as some of the world's largest and best known innovative and creative companies. Before I turn it over to Joe, I'll just mention that all attendees are muted. You can use the Q&A function to ask questions, and you should feel free to pop them into the discussion as we go. We may address them during the presentation, but for sure we will leave time for addressing them at the end. And with that, I will let Joe get on with the presentation. Thank you.
Well, hi there, it's Joe Conneely here, and thanks for the introduction, Jennifer. So we have this presentation is fairly long today, but I think we'll go through it fairly quickly. There's a lot of good examples, and we'll start with those. So let's start it off. Industrial design registrations and design patents. What the heck is an industrial design? So this is what we'll cover. Industrial design registrations. That's the term that's used in Canada. The same sort of right is protected in the US. It's called a design patent. And in different countries around the world, it's called a design patent. Some call it industrial design registration, some call it a design patent. Then we'll look at a few best practices in Canada and the US. So what is industrial design? Industrial design means the features of shape, configuration, pattern, and ornament, and any combination of those features that, in a finished article, appeal to and are judged solely by the eye. That's from Section 2 of the Industrial Design Act. And what that sort of means is that industrial design registration protects only the outward appearance of a product, as shown in the drawings of the registration. An industrial design registration does not protect the function or structure of the product. It only protects how it looks. And there's sometimes you can sort of bend them a little bit to cover function and different sorts of things, but still, it still gets down to what the thing looks like. So here's some examples. So the best sort of way to get an understanding of these is to look at examples, and you might have some questions with these as well. So the first one up here is automobiles. So what you see here is you see a picture of a car, and what you see is most of the car is shown in broken lines. Those are those dashed lines. And then there's some solid lines showing another part of the car, and it's showing the bumper. And sort of the question would come up with something like this is, so what's protected here? It's just the bumper. So it's the look of the bumper, not the whole car in this example. So just the bumper. And the idea would be, why would you do something like this? You would do this to protect your spare parts market. So in a car, when you get in an accident, it's going to be that bumper that gets damaged. So an industrial design on the bumper, the look of that bumper, is going to keep out alternate suppliers, or an attempt to, from supplying that spare part, which would be the bumper. So that's why this is a big application for these industrial designs, is to protect spare parts. And there's a lot of policy, issues around something like this. There's always movements afoot to say we got to limit the duration of protection for spare part type industrial designs, because they're, the original manufacturer is basically cornering the market on the spare parts. Well, that's actually the function of industrial design. So it's a little bit of a policy decision on how you protect these. So that's an interesting one. I think there was some interest in that Jennifer expressed before. But this was what something, a drawing from industrial design for a spare part would look like. Here's more examples. So bottles, the perfume bottle, something like that, and boots, so clothing. We'll keep going. This is alphabetical, by the way. Chairs and coats, again, clothing, furniture. You see in the picture of the chair there, it's just the body of the chair. So the legs are not included in what's being protected because they're shown in broken lines. Here's more interesting ones. So doors for houses, you protect that. Diamonds, this is a strange one. So the cut of a diamond can actually be protected by industrial design. And you think, how do you come up with a new cut for a diamond? But anyway, it's possible. Earrings, earmuffs, different types of things. Footballs, so you see the pattern on that football shown in gray. So it looks a bit different than your normal football. So that's where you're going after there. It's the ornament on that article. And facades. So here, this is I think this is for pink. I'm not sure if they're still around. That's a clothing chain. And so you can't, what you're protecting really here is really sort of a knockdown sort of facade in a mall. So you can't protect regular buildings in this way. You have to, it gets complicated there. But knockdown type facades and these sorts of things or displays can be protected. These can also be protected by trademarks as well in certain circumstances. So guitars, golf clubs, and it's the look of these things again, a little bit different look. With the golf club, you go, sure, it looks different, but there's functional elements to that, but there's still ornament to it. Hammers, the hammer on this one, it looks like they got a numbering down a ruler built onto it. So that's interesting. And handheld. So the any sort of cell phones or anything like that. One of the big industrial design cases, I guess, in the US, it was one of the biggest damages awards. I think it was in the billions there, was when iPhone or Apple sued Samsung for the shape of their iPhone. So that was covered. What that case was really about was industrial designs or design patents in the U.S. And it was a huge award because at the time, I think it still is, you could get total profit on the sale of the item, not just the contribution of any sort of contribution to a subset of the thing, which would be protected by a utility patent. So it was the entire profits you could get on something like that. So they can be quite valuable. These are interesting examples. So you can protect an icon. Again, here, this is showing like a display screen around the icon shown in broken lines or something like that. So you're just protecting the icon here, or a graphical user interface. So something that pops up on your phone or on just on your laptop or something, or for some product or a control system or whatever, you can protect the graphical user interface or even the icons. Here's the iPod again. So industrial design for the shape of the iPod. An interesting thing with this sort of thing, what Apple sometimes does, is they'll file the utility patents, which cover the function of it, not the iPods. I don't know if you get one of those anymore. And then they'll file industrial designs on the look of it. And then once that product becomes well known in the market, they'll get a trademark on the look of it. So we have a trademark for that as well. And that lasts forever as long as you use it. So that's interesting. Different strategies for them. Next thing up is a jet. This looks like an Airbus. I'm not sure what that is, but a jet. And when you do something like this, like for jets or entire automobiles, you'll do the drawing of the jet. You also apply it usually to a model of the jet. So a little toy model. So you say a jet or a model of a jet. Jars. These are jars for food or whatever. Kettles. Kayaks, sporting equipment, kitchen utensils. Kitchenware is big because there's all kinds of design elements. There's a million different kettles. They all look different. You got a really good looking one. You want to protect how it looks. Lamps, so furniture, lounges, lounge chairs, different types of furniture. Back to clothing again, mittens. There's mittens here, microscopes. Neckties, a little bit of different shape on the end of the necktie there. Necklaces, again, jewelry and clothing. Ottomans, again, furniture. And ornaments, Christmas ornaments. Now here's a food one. Here's a food example here. So what we have here is a pizza, the actual pizza. And it looks like like a triangular shaped pizza. And then you have a different box, a pizza box. It's a knockdown box. So this would be protected by, you could get a utility patent to protect how that box is made or how it folds, to get, how it folds up from its what do they call it? I've done these before myself. Anyway, from its blank, I guess you call it, how that's folded into that box. And then the pizza itself is the actual pizza, the look of the actual food item. And next up is a quilt. Maybe a different look to that one. And then a quill. Rings again, revolvers, guns, shoes, slippers. Shoes are big to protect. You can protect different parts of the shoe. This looks like the entire thing. Sometimes you just go for the sole of the shoe, the bottom of the shoe. Sometimes you go for different parts of the shoe you can cover. Toys and tartans. So tartan's actually fabric pattern. That's also protectable by copyright. So there's different overlap, and we'll get to that later on. We'll see a bit of that. So you can actually do these fabric patterns as well by industrial designs, because there's overlap between copyright and industrial design and different types of IP, and there's exceptions to those overlaps. Umbrellas, urns. This umbrella has looks like a golf scoop on the bottom of it. Vases, valets, windmills, and wind chimes. Xylophones. We got everything. Yoga pants, So clothing again, and yoga mats. Zipper poles, that's a big one. Zeppelins, that's a strange one. And that's a good selection of examples. Is that helpful? Probably. Gives you an idea what they cover. They can cover a lot. Now here's the requirements for registration. This is Canada now. Design has to be novel. Now, formally before the Act was updated, they used the term original. And basically what they're saying is it can't have been, disclosed or by another, or it can't be something that's old or that's been known. So it has to be something new. And how new it is, that's the trick. So what they say here, so it's an old case, it's saying you have to be kind of substantially different than what was before. And what that comes down to is kind of tricky. That's where it gets different, because you're looking at how a thing looks. So it's not like claims in utility patent. How do you tell what's different than another thing? And there's that can get interesting, because you're supposed to look at the overall view of the article. But when you're, say, arguing with the patent office, you tend to point out the differences at a different level and then say overall it looks different. So you have to argue those, because once you sort of point out a difference, and these things being visual, it's hard to unsee those differences. The public disclosure, there's a grace period in Canada. We'll also see it in the US too. So you want to get your industrial design filed, 1 year from a public disclosure. And now it's 1 year from the priority date, if there's a priority date, if there's an application filed elsewhere. So 1 year from the priority date, which is often just the filing date of your application, you have to get your application filed. So it's always best to file the thing before you publicly disclose it. But if you did, you have this grace period in Canada, and certain other countries have that too. The US has it, and then it depends on which country you're in. Another restriction, another requirement is it can't just be utilitarian. So it has to be some sort of ornamentality to it. This doesn't come up very much, because most things, believe it or not, they're kind of ornamental anyway, even functional things, unless it's really functional. I don't know, it'd be tricky to find that, like a nail or something. It might be tough with, unless you have different swirls on it. It can be usually you can get around this restriction. Now, what do you get when you get one of these registered? Well, you get an exclusive right, so no one else can basically sell that design for a period of time. So you get your registration. You're good for 10 years in Canada from the registration date. It lasts for industrial design registration for 10 years, or 15 years from the filing date. So usually it comes down to 15 years from the filing date, but sometimes it can be 10 years from the registration date. It's the later of those two. And that's acquired, this right's acquired by the Section 9 of the Industrial Designs Act. So infringement. This is where, so you have your industrial design registration, you get it, and then someone tries to, they try to knock off your product. They're importing it or selling it in Canada, something that's similar to yours. So a design infringes a registered design if it is identical to the registered design or not substantially different from it. And again, this comes down to usually an overall view of those two designs and a comparison. Practically, you are going to point out the differences between the designs and then say, overall, ours is that alleged project is too close to ours, to our registered design, as shown in the pictures or the figures in the registration. So you're comparing it to you're comparing the accused or the alleged infringing item to the drawings that are in your registration. So not to your product itself, which is probably the same or close to it, but it's what's in your drawings. Yeah, this is a little more detail on that. Invalidity. So if you accuse someone of infringing your industrial design, and you start proceedings and so on, one of their defenses is to say that your industrial design is invalid. And the grounds for making that claim as a defense is that you say that, well, it's not novel. And you may turn up prior art or designs from the past that are close to what's covered by the registration, saying, well, the industrial design office didn't consider these or see these. If they would have said your design wasn't novel, so you shouldn't have got that registration. Or it's disclosed by somebody else. Maybe it's not the proper subject matter for registration, or design was published 1 year before the application for the registration was made. That means you fell outside of that grace period when you filed your application in the first place. It was already out there, your design. So those are grounds for invalidating someone's industrial design registration, basically in the context of infringement suit. Now, marking. So this is how you mark your industrial design. If you get an industrial design registration, you can mark it with a D with a circle around it, as shown in the examples here. So D in the name of the proprietor, which is basically the owner. And if you mark it in such a way, if you do have that marking on there, you don't see that often, to tell you the truth. That allows you to go for damages too in an infringement action rather than just an injunction. So there's some value to that marking. Now we'll go on to, are there any questions there? We're doing okay? We're good?
Yep, still good.
Yeah. So the next thing we're going to jump onto here is design patents. So this is a term used in the US. So a lot of the stuff is similar because they all go back to, years ago, back to the original British sort of acts, which the design laws in the US are based on those. And in Canada, way back, obviously they've been changed. So some of the language used is similar. And this is what we'll look at here. So a design patent is the US version of an industrial design registration. So this is what you do in the US. Whoever invents any new original and ornamental design for an article and manufacturer can obtain a patent therefore. Again, it's the ornament, shape, configuration. The terminology here is similar. And again, the design patent protects only the outward appearance of the product as shown in the drawings. It doesn't protect the function or structure. So the same concept. It's basically international for these. Requirements for patentability. Now it gets a bit different. So now if you notice, it's patentability. Because in the US, a design patent is treated pretty similar to a utility patent. So they don't really call it. So it's just a patent, is what they call it. It's a design patent, but there's different sections of the code that deal with it. But there's a bigger overlap with utility patents in the US. So it has to be novel in the US or similar to Canada, maybe a bit different meaning. Again, it's not shown by someone else before you filed your registration, but it's also going to be non-obvious. And what that means is, in the US, is they can combine prior designs, a combination of design elements from one into another. They have to do this in a certain way. They can say your thing's obvious. Now they can do that in Canada too, but they raise it under novelty. They raise it in a different way. So in the US, it's under 103, which is like, if you're familiar with patents, it's an obviousness rejection. In other words, it's argued differently. And how you argue against these is it's sort of convoluted, but again, you say, well, first reference, I don't know if it's close enough to ours to even combine it with anything else. And then if you do, the combination still doesn't show all our stuff if we look at it all together. Of course, you're going to point out what the differences are and then say, but when you look at the overall view, it's still different. And there's a grace period. That's the publication. And again, it has to be primarily ornamental rather than primarily functional. So you're going after, again, the look of it. But the difference here now is you have novelty requirement and a non-obviousness requirement. So it's getting similar to the utility patents in the US. You also have to have a claim in the US, but the claim is for the ornamental design as shown in the drawings. But there's an actual claim. So when they say a non-obvious, they don't say the drawings, they say your claim's obvious, even though your claim is just to the drawings. So it gets, they've got like a theoretical thing going there, and it's kind of interesting. So it's these can be difficult to argue in the US. Again, you get an exclusive right as well. In the US, you get, when your design patent issues, you get protection for 15 years. There's no maintenance fees in the US. I don't think that's covered in here, but once it's issued, that's it. There's no maintenance fees. In Canada, there's a maintenance fee after 5 years to bring you up to that 15-year date, just one maintenance fee in Canada. This is getting a bit detailed now, but infringement in the US is the sole test for design patent infringement is the ordinary observer test. And this is what it says here. And if you look at this, it's kind of similar to the Canadian test as well. So it's kind of convoluted too. You have to establish who an ordinary observer is. So would you be induced to purchase one over the other, looking at the two things, is what the test is. So it's so it's almost like when you read it, it's almost like a confusion sort of thing. That's not the term that's used, but it's similar to that. Am I going to get confused by the other design if it's out there? Is it that similar to mine? Those are the types of questions that sort of come up. It's not a trademark confusion test, but it's got elements of it. Invalidity, again, if you're suing someone in the US, you get a design patent, you sue somebody for infringement, the first thing to do is one of the defenses is to say that your design patent's invalid, for a variety of reasons. Again, they might say, well, it's not novel because there's prior art. There's a single piece of prior art showing it. It's obvious because there's two parts. There's different versions of prior art that can be combined into the rules that could show it's obvious. It's not proper subject matter. And again, you blabbed it or published it before you filed your application or outside of the grace period. There's marking requirement in the US. Same kind of idea. You get a better crack at damages if you mark it. In the US, you'd mark it with the patent number, same as you would mark something with a utility patent number. So just patent number D. US design patents start with a D followed by numbers, and so there's some value to marking it. If you false mark it, you can get fined in the US. So best practices. Take a swig of water. When to file, where to file drawings, and overlapping protection. When to file. So the best thing to try to do, if you can, is if you have come up with a new design, get your application filed before you disclose it, because that gives you the most options. Because in some countries, they don't have a grace period, so you're out of luck if you disclose it before you file, because they'll cite your own design against you. So again, in Canada and the US and in Europe, in the UK, there's a 1-year grace period. Other countries too, they have different requirements from it for it. So there's this grace period, but it's good to get it filed before you disclose it if you can, because then you're in the best shape. You can file, if you file in one country like Canada first or the US first, you can file in other countries within 6 months. That's the international sort of deal with these, and you get the priority. You get the priority of the first filing. So if you file in Canada and so on, if you can tell if your sales are going well with the design, you file in other countries within 6 months of the Canadian filing and claim priority from the Canadian filing. Where to file? You want to file these things in general where you can enforce them and where they're cost effective to do. So Canada and the US are pretty cost effective, especially Canada. Canada's a good deal for filing industrial designs. The US is too. You can also file in Europe. You can also file through The Hague. So in Europe, that would be a registered community design. And you can also file The Hague, which is an international filing system for industrial designs. It's not mentioned here, but Canada joined onto that a few years ago. And what that allows you to do, it's sort of similar to a PCT sort of thing, but it is different. It allows you to file a design and designate countries upfront. So PCT application for patents, you sort of select your countries after 30 months where you're going to go into, as long as you've included them all in the original application, which is done by default. With a Hague filing, you have to designate and pay for your countries upfront. And I think this is what Jennifer was referring to earlier. There's a lot of people file, they enter Canada through the Hague system, and I have a pretty good practice in fixing those those applications that come into Canada, because Canada has its own requirements. The way The Hague does it, when you file an application in The Hague, they're really looking at they're looking for, they don't examine for novelty or say obviousness. They're just looking for sort of almost like practical bars to the thing. You want to make sure your drawings are half decent, and the way you load them up into the Hague application, they usually do look okay, but you can do that wrong. So they're looking for that, and any sort of funny statements, or if there's a public policy issue with your design, which would be extremely rare. So they don't examine it, but they do sort of a examination for formalities. And when people in foreign countries file these and designate Canada, they botch those formalities a lot. Not all the time, but they do. So again, the industrial design applications are examined in Canada. So someone's looking at the thing, they look at it, and they compare it to prior art in Canada, US. Other countries, they don't. They just look at it for formalities. That sort of examination may be done later if it's going to be litigated, or it's done in litigation itself. So it's more of a registration system, and in Canada, US, we examine. So it's different. Other countries examine too. It depends on the country. The drawings. So drawings are the big thing with industrial design registrations, because it's all about the drawings. Because the drawings are really the claim. It's what you're trying to protect. So they have to look good. They have to be consistent. Because you can get rejections when you're prosecuting the application if there's inconsistencies between views. What that means is that your perspective view, say, doesn't look like your front view. It's got extra lines in it or extra features that aren't in another view. So they have to be consistent. You get a rejection. They have to be good quality so they can be seen, and that sort of thing. Best practice. Show the complete finished article in isolation. You usually need one. Most countries need one view of that, and some of these requirements have changed as well. Show design in solid lines. If applicable, show portions of the article that are not part of the design in broken lines. So that's what we saw with that example with the automobile and the bumper. So stuff, if you have, say, a chair, again, or the automobile, and you're only interested in, say, the bumper of that car, you show the rest of the car in broken lines, and you show the bumper in solid lines in all of your views in that for that particular design application or variant. Again, the drawings have to be clear and of sufficient quality to be reproduced by photocopying. Now, that's a bit different now, because most of these are all filed electronically. So you might have a PDF file you upload in Canada. In Europe or in Hague, for the Hague system, you're going to upload a JPEG or a TIFF file. It's going to be pretty clean and looking pretty good. Has to meet size requirements and so on. So but the drawings still have to be good. You know, if they're lousy drawings, they'll reject you for being unclear. Include as many views as is necessary to show all features of the design. And this ties in with the portions that are shown in broken lines as well. So say that car, if you look at the front view of that car, it'd all be in broken lines. So you can include that drawing or not, but some countries, they want you to have 7 standard views. It depends on the country. They want a perspective, front, back, top, bottom, right side, and left side. just because those are the standard views. Other countries, you may only need to show the views that are required to show the thing that you're trying to see. Include view numbering. Sometimes this is automated by whatever the system you're using. And if you're doing a paper, standard sizes. And you're looking, so they make it easy for them to reproduce it electronically when they issue the registration or design patent. We saw black lines on a white background. This is for line drawings. You can also use photographs and so on as well, or different types of drawings as well. You can also use color now as well. There's tones of gray in here. You can also use color as well. And you can specify whether color is a part of the design or not. And photographs are a whole other story, because you want to have good quality photographs. They end up probably being the same price as good quality line drawings, maybe more for the photographs. Some things very hard to draw. So photograph may be the best thing to use, as long as they're basically professional type or professionally done photographs. And there's requirements of those for those set out in the various guides. Now here's this broken line stuff again. You spelled stippled lines. Now it's basically just broken lines. And this is what it means. So if you think of a claim, like what are you trying to cover here? So we just got, what do I have? I just have an oval and a square box. And one's a narrow claim because it includes all of it. So all the lines are shown there. And the broader claim, well, it just includes the oval. It's the same article, but the outline rectangle is reduced to broken lines. So you're just covering the oval shape, whatever this is, and you get a broader claim, a broader protection with that broad claim, because you're showing basically less of the article than the narrow claim, which has more of the article shown. So when you infringe, someone's infringing something, and it gets complicated with this, basically, but you're only chasing them for if you have a broad claim, is if they show that, basically that oval. And there's other considerations too. So that's the idea there. Otherwise, you'd have to show that they took all of it. So which would be the narrow claim. Any questions on it? This is big. This is important because this is how you shape how much protection you get by your design.
No questions on that, but there are a couple of questions that have accumulated in the chat. Do you have time to go through those now, Joe?
I think we just got a few more examples of drawings here, and that's, yeah, so sure.
Okay, so question number 1, does the argument of novelty of design hold up only within the same industry or function? So for example, if someone makes a makeup brush that is a similar design to a paintbrush.
Depends where you are. So sometimes they'll take into account the title. And then and it depends on how they raise the rejection. So in the US, if I remember right, if it's a brush and they're saying it's not novel, they can probably get you with either brush. But if for obviousness, it may have to be within the same area. And it's wishy-washy on that. So you could get a rejection or not. I don't know if that's clear, but it's hard to, I've seen those, they'll whiz in something funny, especially under novelty, because it doesn't have to be in the same field for that. You can actually get something wildly different, and you're going to argue, no, it's a different thing, but in obviousness, it tends to have to be in the same field. Does that help?
Yep, I think that's good. And
you also want to sort of make sure your title, you can just call your thing a brush too.
Yeah, I think this is the kind of thing where it would make sense to take advice from a professional advisor about it. It will depend on which jurisdictions you're interested in filing into.
In some places, it's really on the class. Sometimes it's even on the class, really. But what it falls into. But you want to, in general, you may go for a broader title. So in Canada, they may force you, like for example, if you have some article of clothing, say you have shorts or something in the US, you might just call that a garment. And then because it can have an effect, And there's case law that goes back and forth on that because that comes up. So you might call it a garment. In Canada, you may try to call it a garment, and they may say sometimes they'll take it, sometimes they won't. Sometimes they say those are shorts, so you have to change the title of it. So it may be called a garment in the U.S. and shorts in Canada, and maybe shorts in the Hague registration. You can try either one because they may want it to be they might a tighter name on the title. So that's anyway. Okay.
Okay, and question number 2. Can you address the interplay or relation between industrial design with trade dress in the US and Canada? For example, why would you file for one approach or not the other? Also, how does the industrial design regime come into play with counterfeit goods and associated infringement enforcement?
They're different. Oh, let me go down to I have slides on that coming up, so I can get to that. I'll get to that in a second. But they cover different things. So the trademark's trying to protect the source. So it's a source identifier, and you might have to establish other things to get a trademark on a design. You might have to show that it's well known or acquired distinctiveness. You don't need to do that for an industrial design. So it's probably a quicker process with the industrial design, and you can do both. So you can do by all means do both if you have the requirements for that trademark, which may be higher. It depends. It depends on what it is. And so that's the thing. So you don't have the requirements of industrial design, show them in the pictures. That's it. The trademark though is good because it lasts forever as long as you're using it. And then industrial designs have a shorter term. So that's them. Now, what's the other part of that question? Can't remember.
So how does the industrial design regime come into play with counterfeit goods and associated infringement enforcement?
It's the same. If they're knocking off your thing, counterfeits really, you're trying to say that, it doesn't go like that because this is just, does it have the same design? So if it does, you don't have to worry if the guy's trying to pass it off as your thing. He's cloning your design. So if you put labels on it and stuff, it doesn't matter. Like you might have they may try to be passing off, I don't know, like a Gucci bag as a Gucci bag, but it's not from Gucci. So that'd be a counterfeit. But what the industrial design covers is just a look at the bag. That's it. There's no, it's not a passing off thing or a counterfeit. It's a clone of your design. So you want to get them with both if you could, is I think the idea.
So just before we move on from the slide you're on right now, I wonder if you can explain a little more about the scope of broad versus narrow. So if you'd filed a design for this the narrow claim with the square and the oval, so what would you be required to prove to show that it was infringed?
For the narrow one? Oh, yeah. that it shows that the infringing article looks like that. So it has all of those features basically.
Right. And so if it was the broad claim instead, so if you had filed with the stippled lines around, the broken lines around the outside, that means that even if the infringer had like round edges around the outside instead, or a hexagon or something else, that as long as they took the oval part of it, they're infringing?
That's right. So that's basically right. Now there's other things, like they might say they might have taken the oval part, but they may have something else that adds to that changes the way how that oval part is perceived. So that would be different. And that's getting esoteric, but basically, that's basically correct what you're saying. So if you can imagine what would that look like? Say that's like a scarf. Remember, there is still a title to it, So say that was I don't know, it looks like a blanket. Say it's a towel with that oval thing in it. So if they have a towel, they might have fringes on the end of their towel, but we're not claiming that. We have the say our towel is, and it's what's shown in our drawings as well. So say our towel is exactly what it looks like. Say our towel looks like the narrow claim drawing, but what we file is the broad claim one. So if they come in and do something like the narrow claim one with fringes on the end, chances are they're going to be found to infringe ours, because even though theirs have fringes on the end, which is an add-on, they still take the broad claim of the circle and thing, because they still have that part, and that's what we're covering. Unless their crazy fringes are so spectacular that it changes everything. It's hard. That's the hard thing to express. So basically, you're right. That's what it means. If they do the circle and then you've got them. If they just do the oval.
Great, thanks. That was all the open questions. So you can.
This is always confusing because you might say, well, I got an oval, but I have an oval, okay, and so, but I have a giant flower in the middle of my oval, and then you go, well, does that mean they've taken the oval? It's a giant flower in the middle of this oval. So it becomes a different thing. So you have to look at, again, there's looking at the overall design as well. Do you know what I mean? Do you know what I'm saying there? Like, say they put on a giant flower in the middle of that oval. Would it be the same as your oval? You know, so there's that question too. But on a basic level, this is what it means. If they came out and said, well, you know, ours was a little bit longer or something, or it had something there that's you'd get them okay on that with a broader claim. Okay. Any other questions there? We'll go on. Some of these are covered in the next thing.
Yeah, that was it for the open questions. Thank you.
That one's always a tricky question. Everyone always brings it up, but it's, yeah, that's what it is. Sample drawings. Got some sample drawings here. These are old ones though. So a different view. So we mean by a front view, a back view, right side, left side, perspective, or in-use views. Those are sort of the standard views. Again, there's 7 standard views. You tend to go for those, but it depends on the article and depends on the country. So a lot of countries want every view, and other ones, you just need the ones you need, say Canada and the US. Here's some examples. This is front view, rear view, right side, left side, perspective, or in-use view. So here's here's this overlapping protection again. So patents, trademarks, copyright. So for patents, the functional features of a design may be protected by a patent, while the visual or ornamental features are protected by industrial design. So if you look at that, again, back to that bumper again, you can still get a utility patent on the bumper because there might be something to it on the function of it, or you get the look of it by the industrial design. So here's the trademark question. The trademark distinguishing guise, that was the old term, or trade dress design. And here's some examples of how these kind of play off each other. Yeah, there's also another thing there. So when you think of things like the Coke bottle, again, and the iPad, so those started off as industrial designs, and then they became trademarks over time because they acquired that the distinctiveness or the requirements for a trademark to be registered as a trademark. But a Coke bottle and the iPod, again, these started off as industrial designs. So that's kind of that's almost the best way to address that, because there's sort of a sequence to doing these things in some cases, and it helps to have the design there. There's also overlap with copyright. So designs apply to useful for, and there's a quantity thing in here with the copyright, with the Copyright Act. So over a certain number of items, you have to go for an industrial design copyright under that. However, there's the big thing is there's exceptions to that, and one of them is fabric patents, and then certain dolls and toys, if they have certain features on them, they're covered by copyright instead of industrial design, and that stuff's in the Copyright Act. Those those exceptions. And one of the big ones is the fabric patterns. You go, hey, I thought that was copyright. You go, it is. But also you can get industrial design. So the tip here is obtain as many forms of applicable protection for your design as possible. So if you got a really cool design and you've been doing it for a while and it sort of identifies you, you got to go for that, go for the trademark for sure. Now, let's see what else we got. Oh, now we're at the questions. So if there's any other questions, those are the good ones.
Well, I'm seeing none on the Q&A box, but I have a couple of questions. So first I've got to ask, because we're Protein Industries Canada and we deal a lot with food products and ingredients and you know, processed stuff for say animal feed, etc. Does the design have to be pretty in order to be registrable?
No, it just has to be novel. But what do you do? So the food items are interesting. I did a candy yesterday. It was on a Monday. It was a big candy thing. So that's not really the same. But any sort of they come up. So candies of pizzas. This actually exists, or chips. So anything like that. If there's a shape to some of the products, even the industrial products, that can be an industrial design, right? It's kind of obscure to do, but it could be. Even pellet shapes or different things like that. It has to be something new, right? They're kind of difficult to do. And you wouldn't believe what people try to put industrial designs on, especially any sort of containers or parts of products. Think about spare parts again, or parts of any sort of medical devices, all the little parts that go with it, all the user interfaces that go with it, on displays on your phone, to use this type of thing. These are all covered heavily by industrial designs. They got patents like crazy on this stuff too. But if they got deep pockets, they're filing industrial designs on this stuff like crazy because it's cost effective to do. So any sort of portions of containers, portions of test equipment for medical devices and things, the actual medical device itself, how it looks, all of that stuff they'll cover by industrial designs. And then do you have any specific things within the industry you're thinking about there? Like,
well, I guess just shapes of finished food products, or maybe shapes of packaging that.
Sure. So it's all the pizza boxes, all that stuff. So all of that stuff for sure, and you get the trademark stuff on that too as well, right? So that you can that's don't forget your trademark. So, but all the shapes of those products. So we sell the pizza box, any container shape, stuff, disposable food containers, plastic containers, stuff you put pies in, anything like that. A lot of stuff again is covered by copyright and trademark, but it's industrial design's another one in there as well, and utility patents. So any of the containers for all that stuff, different bag shapes, you've all kinds of stuff in there, So it doesn't have to look good.
Great. Now, I imagine that a fair number of the people who are joining us on the call today are with smaller organizations, and you may be concerned about budget. So can you first of all just give a sense of the relative costs of patents and industrial designs?
Yeah, so industrial designs, so the way they're charging in Canada for it, they change the price by like a couple of % every year. So the actual filing fee in Canada is some oddball number right now. You have to, every time you file one, it changes. No, not really. So it's like $430 right now, plus 50 cents, or something like that. So that's your government filing fee for 10 pages of drawings or less. So if you have a normal sort of, say you've got a chair and you've got 7 views or 8 views of it, you're within your 10 pages, it's $430 plus change for the filing fee. Then you got to get those drawings prepared. So the drawings prepared, you may be good in-house doing that. So I've got clients who do their own drawings because they're good. They have 3D models and they're doing things with that. There's some different requirements for industrial design drawings, but they can actually shoot off the drawings. They're going to look pretty good. So they can do that themselves, or you order your drawings from professional guys that do professional drawings for industrial designs and patents. The difference between industrial, you can use the same drawings for both sometimes. Those industrial drawings, you're trying to make it look good. And you also want it to be, it's also a marketing tool itself. So when you get this registration, if the drawings look good, especially US design patents, you have this thing, which are going to become electronic actually in another month. They look good. So a little bit of a marketing thing with them as well. So if you got good drawings and then they're clear, you can sort of wave this thing around, and it's a little bit scarier if they look professional and they're good. And those, they might cost you $500 to $1,000, depending from a professional guy's doing them. Depends how fast you need to get them done. It depends on how many views they are and how complicated they are. You can also do them yourself, but they can look bad. Or if you're used to them, they can look pretty good. So it depends. So there's funny requirements with them, and they're laid out. But you want to kind of, once you're used to doing a lot of these, you know it looks good and looks bad. But so professional ones say 500 to 1,000. I filed industrial design applications with over 300 drawings in a single application, and that's going to buckle the Canadian system. They have to handle those differently because they're so big that they wonk out. They'll accept it, but it just goes insane. So they'll actually have to handle those different. So they can be huge, and those would be very expensive applications. And people do deep pockets for those. And they have like 100 variants in them, or different embodiments, different portions broken down into broken lines and so on. So there's all kinds of things like that. So that's the cost there. Then the cost of the filing application. So the filing fee, we got the drawings fee, mostly for the drawing fee. Then the fees for filing it, or you know, it depends on how long it takes. Like you're talking $1,000, or usually, you know, sometimes you have to fix the drawings. It can take a while to get the drawings done right. So several iterations to get drawings finished by even professional guys, because they'll botch a view. It's very hard for people to draw. It depends what the item is. So if it's clothing, they'll botch perspective views because only the very good guys can draw them, because they have to draw them by hand a lot of times. So they don't have any model. They might not have a model to draw it from. They may be drawing them from technical flats. So they have to put shape to them. So they're different. They can be difficult to do. Others not. If it's coming right off a 3D system, you've got all your views. Select your views, correct the shading, use line shading instead of solid shading, things like that, and you can do okay. So a lot of times you're into iterations of drawings to get fixed. I'm talking 5 or 6 iterations on some things to get them correct. And that's for something that's going to be filed in the US. They're very particular about the drawings in the US. A little bit less, they're particular in Canada too, a little bit less. In the US, they got software and stuff where they line up their views to see if they're consistent. And if they're not, you get a rejection for that. Then you have to fix the drawings. So it can be tricky. So it's so that's it. So you're talking up 2,500 to 3,000, I guess, for a typical one. You got a huge one, it's going to cost more. Utility patent is, you got drawings too. I'm doing one now. I don't know how many drawings. I've got 50 drawings. I need to get back to that. A lot of those they're done. The level for consistency between views is completely different. You're just trying to show the function. You're labeling parts in a utility drawing. They don't have to be consistent between views. As long as you say they're not consistent, the industrial designs, they have to be consistent, or you're gonna have a problem. You may have a problem if you try to enforce it if one drawing looks different than another. It's one of the things you want to maybe go off. Usually they can argue around that in litigation, but sometimes they can't, because one view has an extra thing on it and one does not. So they can be problems. You want to be consistent. So in a utility patent application then can cost, depends if it's provisional or not, depends where you file it. You're talking 10 to 15,000, I guess, usually. If it's complicated, it can go more. If it's really complicated, it can go a lot more. And I'm talking mechanical, electrical. If you get into pharma stuff, it can be who knows what the price would be on that.
So it sounds like it's safe to say that designs are far cheaper than patents.
They're different. Yeah, they're different.
Narrower, perhaps, and you know, a different scope, because they're really about the drawings, but they can be a much cheaper option. You could file multiple designs for the cost of that you'd pay for one utility patent.
Yeah, yeah, you can do that. But I guess the idea with that too is it's just different. So you have to look at, or you want to protect the look of your thing, and certain things, yes, you do. So if you have something that, if you got the coolest looking new chair, you want to get that thing protected, or something like that. If it's it could be component parts or something. And then what you're doing, although they're not supposed to overlap, when you're starting to put stuff, industrial designs on component parts, you're actually protecting the function. You're not protecting the function, you're protecting the look of it. But it gets kind of blurry in there because you're protecting different parts to something that may not be replaceable and that sort of thing. So they become a strategic in a different way. But if you want to cover the look of something, utility patent's not going to do it for you. It's got to be an industrial design. So if you're into that, you're coming up with products that have a look to them in those industries you do. Think of kitchen utensils and things, or all those examples in there. That's what those things are highly useful for. You might have some really cool, your sales could all be built around how your thing looks. It's a toaster, but it could be the toaster that everyone wants because it looks cool, or whatever, that sort of thing. So so different purpose is really what the message is. The cost is different, but the protection is different.
Well, I'm cognizant that we've reached the top of the hour here, so I think we should probably wrap it up. But first, let me highlight an upcoming webinar that may be of interest to attendees on this call. Lifting the Veil on Trade Secrets is a webinar about trade secrets with speaker Barry Suchman. It'll be hosted by our sister innovation cluster, NGen, on March 9th at 1 o'clock Eastern, 10 o'clock Pacific. You can get the registration link through the NGen website, or we'll see if we can pop that into the chat today before we finish up. And we will also include, Joe, your email address so that people can reach out. I'm such an industrial design geek. I could just talk about this absolutely all day, but I want to encourage people to reach out to you and ask any questions that we didn't get to today, and get your advice if they have specific matters that would be suitable for industrial designs. Thank you very much, Joe, for this wealth of insights today, and thank you, audience, for your questions and your attention. Take care and enjoy the rest of your day.
All right, thanks a lot.